Yeah, Lordship.
Yes.
Lordship, I beg to mention one unlisted item, which is this is criminal appeal 09/2024, which is pending before this court. So I was praying, my prayer is for listing for tomorrow, Lordship.
For listening tomorrow.
Lordship.
For
For
listing.
tomorrow, for tomorrow. Oblige.
My lordship, I beg to mention item number 19
19.
on behalf of Mr. S. Tapin.
Okay.
This matter may be listed tomorrow, my lordship. I have taken consent from the respondent.
Tomorrow. Okay. Item 19. On the prayer of Miss Such and Such, mention has been made on behalf of S. Tapin, learned counsel for the petitioner, appellant, to list the matter tomorrow. Prayer is allowed to list the matter tomorrow.
My lordship. Lordship, I beg to mention item number 14, lordship. Matter may be listed after 3 weeks, lordship. I take consent from the other side, lordship. 14,
Item 14.
lordship.
You mentioned when the matter reaches, only hearing matters may be mentioned.
Lordship, item number 6, my lordship.
16.
Matter may be listed after 2 weeks, lordship.
Wait, just wait for your turn. Okay, I'll adjourn it, no problem, but just wait for your turn.
Oh.
Okay. Any mention matters in hearing? Anyone? Hearing matters 12 to 20.
Your Honor, item number 7, I would like to mention.
Part 1 item, part 1 matters, please don't mention now. You mention when the matter reaches, when it is called out. Okay.
Yes, Honor. Yes.
Yes.
My lord, I beg to mention item number 20. Consent has already been sought from the other parties. Item number 20.
Okay, for when?
The learned counsel is out of station.
Okay.
It
So
may
when
be,
do you want it?
for 23rd of April. On 23rd of April.
23rd of April. On the prayer of the councils for the parties, list the matter on 23rd April 2025 for hearing.
Much obliged.
Your Lordship, I beg to mention item number 17. I am appearing on behalf of petitioner. Leading counsel from personal difficulties is not able to argue the matter.
So when do you want?
Your Lordship, this matter may be listed after puja or a view
After
break.
the view break. Okay, mention has been made on behalf of leading counsel, Mr. T. Pangi,
Yes, Your Lordship.
who is out of station today. This is the matter after the view break.
Out of the personal.
Lordship, I beg to mention item number 18. Here, I am the petitioner. Actually, this leading counsel is out of station.
You are for
Petitioner,
petitioner,
yes.
appellant. This is criminal appeal, na?
Yes, 18.
So when do you want?
Lordship, matter may be fixed on 20th of this month, April. 20th April.
List the matter for hearing on 28th April 2025 on the prayer of the learned counsel for the appellant, who states that the leading counsel is out of station. Yes.
Lordship, please, item 10 also.
Wait.
Much obliged.
You mentioned item 18 hearing, no?
Yes.
28, you wanted on 28.
Yes, Lordship.
28. 28 April.
Lordship, this is a criminal civil review revision petition challenging the impugn order dated 12/03/2025, passed by the SGB respondent number 2 in the village level cover. Lordship, in the year 1988 and 1995, two Kava decision was passed on behalf of me. Uh, and the respondent number one never filed appeal against the two Gaba decision, and same has also, I think it's final. And moreover, LPC has also been issued on behalf of me, but they never challenged the LPC. And respondent number one has been encroaching my land despite the Kaba decision and so cause notice issued by the DC to them, and were also illegally selling my land.
Same subject matter, same parties
Yes, Lordship.
before the DC. Okay, we'll issue notice at this stage.
Chief,
Yes.
even after so cause notice issued by the DC, the petitioner's son again encroached the lane, and I filed FIR in police station, Alo police station, and during the pendency of this matter, a parwana was served on me that the Kaba will be held on
So where is the impugned order, the Gaba decision? Gaba decision is at page
Kaba decision is on 52.
23.
Yes.
Translated copy. Okay.
Mention.
There was distribution of properties of someone. So you're aggrieved by this in page
Impugned order.
23. But you said you were saying that you have been directed to pay a sum of one
Yes,
lakh
Lordship.
42,900,
Yes, Lordship.
isn't it? So where is that?
Lordship, page number 53, annexure 5, 16. Lordship, translated version is 59.
Page
59.
59. Total rupees 1 was passed to be paid to You see your prayer portion. Motion set aside impugned Gaba decision dated 12/3/05. So you're coming against this order of 12/3/25, isn't it?
Yes, Lordship.
Page 57. This application has been filed under Article 227 of the Constitution of India, read with Section 115 of the CPC, praying for setting aside and quashing the impugned Gaba decision dated 12/3/2025, passed by the head Gampura of Biru Village, West Siam District, Arunachal Pradesh. Issue notice to the respondents. Petitioner shall take steps by registered post with AD within a period of 3 days. The notice is made returnable within 4 weeks. Is the matter after 4 weeks. You're pressing for interim.
Yes, Lordship. Lordship, in interim, the impugn order dated 12/03/2025 may be stayed.
In the interim, the impugn order dated 12/3/2025 is stayed till the next returnable date. Yeah, that case, no? I have inquired from the registry and it is functioning, the court is functioning. Yes.
We went there and we came return back with the statement that there is no court function.
No. When the registry has already said that it is functioning, this matter is disposed of with a direction to the petitioner to approach the court of the learned district and session judge, Sepa, East Kameng District, Arunachal Pradesh, as it has been clarified from the registry of this court that the concerned court is functioning. So, learned session judge Sepa is coming. Arunachal Pradesh shall entertain the application and decide in accordance with law.
Yes. Oblige, Your Honor. Deeply oblige.
Your Lordship, this is a bail application for the release of the accused person who has already completed 1 year in the judicial custody. He was arrested in the year 2020, in the month of April 08, in connection with a Bandadua PS case.
Wait. Date of arrest. 8/4.
8 for you.
8/4/2024. Which sections?
Under section 21B of NDPS Act. Your Lordship, this is a
So that's intermediate quantity.
intermediate conduct.
Hmm.
Your Lordship, earlier 2 bail application was filed before a special judge UPI.
Okay.
So first bail was rejected.
Hmm.
The rejected bail order is Annexure 1. By the order dated 3/12/2024.
Page 12.
3/12. Thereafter, a subsequent bail application was moved.
Wait. First bail rejection, page 12, annexure 1.
Annexure 1. And subsequent bail application was moved. It was taken up in the month of February 12. But Your Lordship, till that order has not been passed by the special judge.
When was it heard?
It was heard on 12. February 12th.
2nd February.
Yes,
Or February 12th.
February 12th. 2 months has already been lapsed.
So we'll direct the session judge to give the order, pass the order.
Yes, Your Lordship, and Your Lordship, this application has little urgency because Your Lordship,
So we'll tell the session court to dispose of the earliest, isn't it? That can be done. But can you give the bail application number?
bail
The
application
one where order was not passed?
457/2024.
Where is that?
Annexure 2.
A 457 of 2024. This should be actually special court, isn't it?
Yes.
Special court NDPS.
Special code NDPS.
We'll give a time frame and then.
Your Lordship, on coming 16, this 16,
Hmm.
evidence has been fixed.
Hmm.
Examination of the IO and the complainant.
Hmm.
So your Lordship, because of the detention, continued detention of the accused person in a judicial custody, it has become difficult to communicate with the accused person to come up with a defense. Your accused has a very good case. There is a chance that accused might get acquittal. Therefore, your Lordship, if the accused during this
See, if
period.
matter has already been heard by
Yes.
the special court, let that be disposed. Okay.
Okay.
And after that, if the order is not favorable, then the liberty is always there to come here again.
Yes, Your Lordship.
This is an application under section 483 of the BNSS, praying for granting bail to the accused Arif Aslam, ARIF Islam, who was arrested on 8/4/2024 in connection with Bandar Dewa, BANDERDEWA, Bandar Dewa Police Station, case number 32 of 2024 under section 21B of the NDNPS Act 1985, arising out of FIR dated 8/4/2024. Stop. Learned counsel for the petitioner states that he was arrested on 8/4/2024 and thereafter he had filed the first bail application on bail application being BA number 439 of 2024, which was rejected by the learned special judge NDPS UPIA by the order dated 3/12/2024. It is stated that a subsequent bail application was moved before the same court, which was registered as bail application number 457 of 2024, and accordingly, the hearing on bail application was taken up on 12/2/2024. Stop. It is contended by the learned counsel for the petitioner, Shri such and such, that the learned special judge NDPS UPIA has not disposed of the said bail application 457 of 2024 and no order has been passed till date. Stop. Hence the present application before this court. Stop. Learned PP is present for the state of Arunachal Pradesh, and he has contended that the learned special court NDPS may be directed to dispose of the bail matter 457 of 2024, which is pending before the court. Stop. Next paragraph. This court has observed that the petitioner has annexed a copy of the certified true copy obtained from the learned special court NDPS learned special judge NDPS UPIA dated 12/2/2025.
Your Lordship, this is an application applying for the certified copy.
No, that's right. You had sought for a copy of the order of bail application 457 of 24, nah? But since no order was passed, you didn't get anything, isn't it? You didn't get any order. What did I say? Application for CTC, nah? Yeah, application for CTC. Yeah, dated 12/2/2025, wherein he had applied for through which he had applied for a copy of the order passed in bail application 457 of 2024. Stop. However, it was seen that no order had been passed and the bail application 457 of 24 had not been disposed of. Stop. Accordingly, this petition is disposed of with the direction to the learned special judge NDPS UPIA to pass necessary orders in connection with bail application 457/2024 expeditiously. Stop. The matter stands disposed. Just say disposed.
May I, your lordship?
Yes.
Your lordship, I am for the respondent and the counsel for this matter, K. Lolan is been absent and
It's okay.
he's not been able here, so matter will be listed after this puja break.
It's connected, no, 4 and 5.
Yes, your lordship.
So you're mentioning on behalf of
K. Lolan.
Respondent.
K. Lolen. Prayer is made on behalf of K. Lolen, counsel for the respondent, to list the matter after the BO break as the council is out of station.
Yes, your lordship.
Council is out of station. So. Then PP is present for the state. Prayer is allowed, list the matter after the BO break. For admission.
Obliged.
Obliged.
My lordship, this matter may be listed after 2 weeks, lordship.
The 2 weeks.
Oh.
You're mentioning on behalf of
Petitioner.
petitioner.
Petitioner lordship.
Counsel for the petitioner, Shri such and such, who prays that the matter may be listed after the BO break. List the matter after the break.
Obliged. Obliged.
Your Honor, I'm for the petitioner and would like to beg for adjournment, and case may be fixed on 28 or after 28. The same has
Let
been,
it come up in May, no? Because we have posted many matters after vacation, so let it come up in May.
yes,
first
Your
week
Honor.
of May.
Lordship, I'm for the private respondent here in this case.
No objection. no?
Yes, but lordship, but many adjournments have been taken by them, so I pray for a fixed date.
Okay, you give the date then. First week May,
Lordship, if it is first week of May, then on 5th?
5th.
Yes.
5th is okay.
Yes, Your Honor.
Lordship, it may be observed that this
No
would be the
further
last, yes, no further, because Lordship may see the records, that so many adjournments have been taken.
All on the prayer of petitioner only. Why
Yes.
you don't want to take up the case?
Since the leading counsel is out of station, therefore.
No, other times also petitioner has always been, anyway. It has been mentioned on behalf of the petitioner that the leading counsel is out of station. And therefore, the matter may be listed on 5th May 2025. Learned counsel for the respondent number 3. And the learned PP are present. No, respondent number 2, no? Learned counsel for respondent number 2.
Respondent number 3,
Yes.
Lordship.
Oh, 3.
Yes.
Respondent number 3.
I was implemented later
Oh,
on.
okay. Respondent number 3 and the learned PP are present. It has been observed that several adjournments have been taken on behalf of the petitioner in this matter. Accordingly, it is directed that no further adjournment may be allowed on the next occasion.
Obliged.
Most obliged.
5th, okay, 5th.
Your Honor, Supreme Council, he's having some health issues, Your Honor.
My lord, here in this case, they have initially filed an anticipatory bail. Later on, your lordship, they challenge the FIR entire proceeding before the Honorable Supreme Court. And the Honorable Supreme Court, your lordship, has passed an order that no coercive action shall be taken against the petitioner. So, your lordship, in presence of
So,
that order, your lordship, there
This
is,
is infructuous.
yes,
Yes.
exactly, your lordship. There is no requirement for your lordship go
Ah.
for the anticipatory bail, your lordship.
Top court of the country has protected you.
Yes,
So
your
what
lordship.
more order you want from here?
Just, I'm taking this, praying for adjournment, Your Honor.
No, there is no need to keep it pending
Yes,
only.
yes,
This
yes.
one,
Exactly, your lordship.
I'm disposing it of, okay?
So this is the, your lordship has got
Yes,
the order, yes,
yes.
your lordship.
Your Honor,
Order dated 3/3/25. isn't it?
Yes,
Three. Order dated 3/3/25, Supreme Court, you have a copy.
yes, Your Honor.
Three 25, and your lordship on
3/25.
6/3/25, the same, this read criminal has been mentioned before this honorable court, which is reflected in the order itself, your lordship, on 6/3/2025.
The petition number does first. This is an application under section 482 of the BNSS, praying for pre-arrest bail in respect of the petitioner, Shri Amulya, AMULYA, Senapati, Shri Amulya Senapati. Stop. Learned counsel for the petitioner has prayed for adjournment on respect of his senior being out of station, isn't it?
Yes, Your Honor.
So, however, it is seen that the petitioner had approached the Honorable Supreme Court in WP Criminal 64 of 2024.
Your lordship, they have mentioned 53 of 2025. Your lordship, fine in the order.
But wait, the name, no? The name of the petitioner here is Amulya Senapati. Whereas this one is Saroj Gohain.
Your Honor, this matter may be,
Your lordship, there is not only one, your lordship, two read criminal is there. Your lordship will find IA number, Honorable Supreme Court order, read petition criminal 105 of 24 and read petition criminal 53 of 2025.
105 of 24, 53 of 20. So which one is yours?
His is 53 of 25.
53 of
Yes, Your Honor.
25. So let just say like this, has filed WP Criminal 64 of 2024, along with WP Criminal 105 of 24 and WP Criminal 53 of 2025.
Yes.
The matter pertaining to the present petitioner is WP Criminal number 53 of 2025. Stop. In the said matter, the Honorable Supreme Court has passed an order on a common order on 3/3/2025, wherein it has been directed that no coercive action shall be taken against the petitioners in WP Criminal number 53/2025, subject to their continuous cooperation with the investigation / trial. Stop. Next paragraph. This court had passed another order on 6/3/2025, wherein the court has also mentioned that the petition numbered as WP Criminal numbered 53/25 is pending before the Honorable Supreme Court. Stop. And the learned counsel for the petitioner had submitted before the court that the petitioner has appeared before the IO and cooperated in the investigation of the case. Stop. Next paragraph. In view of the order of the Honorable Supreme Court dated 3/3/2025 in WP Criminal Number 53/2025, the present petition has become infructuous and hence it is disposed of as infructuous.
Deeply obliged.
Your Lordship, in this matter, as per office note dated 7/4/25, service report upon respondent number 2 is still awaited, Your Lordship. Respondent number 2 is the complainant, Your Lordship.
The OC is supposed to send the
No, that
service
has
report.
already been sent.
So further 2 weeks time may be granted, Your Lordship.
Or else, Your Lordship, since 2024, service report upon R2 is still awaited. In that case, Your Lordship, this honorable court may direct registry to appoint legal aid counsel.
So, Your Lordship, that-
Or PP can just remind once, na?
yes, exactly, Your Lordship. If
Yeah.
service is complete, then legal aid counsel comes. If service is not
Yes,
complete, Your
The
Lordship.
thing is, it has not returned from the OC, that's the problem, no?
Yes.
It has to come back. So
Gotcha.
if it comes back, then the court will appoint.
Yes.
So PP can just.
Yeah, we'll give the
remind
reminder to the OC,
remainder
yes.
once. Office note dated 7/4/2025 indicates that service report in respect of respondent number 2 has not yet returned from the OC. What PS? Doimuk. Doimuk PS. So accordingly, list the matter after 2 weeks, awaiting the service report on respondent number 2. So learned additional PP. The ethics shall take steps to remind the OC for the same.
Yes.
Obliged.
Deeply obliged, Your Lordship.
My Lordship, I am praying for this adjournment of the case because the leading counsel is of the station on medical ground.
On 19/2 also leading counsel was out of station.
Yes, 18/1, same counsel is there.
T Takyang.
Yes,
Topu.
T Topu.
No, your senior
Yes, T Topu.
and you are
I'm T Tamin, Tokdak Tamin. 10 and 18 is same.
10 and
18 is 10 and 18.
item number 10. Mention has been made on behalf of T Topu, learned counsel for the petitioner, that the petitioner, the counsel is out of station. Accordingly, list the matter
Yes, after 3 weeks.
after 3 weeks.
Obliged.
Obliged.
Your Lordship, before my learned brother proceed, Your Lordship, I would like to apprise Your Lordship that Your Lordship, here in this case, the informant was IO and this case is pertains to NDPS case. So in my humble understanding, Your Lordship, the IO will not be required as an respondent number 2, Your Lordship. Because it's a NDPS case, Your Lordship. Normally, Your Lordship, the IO, they on the reliable source, they lodge an FIR. So we will represent, Your Lordship, both.
Okay, yeah, not necessary.
Yes, Your Lordship.
Then may I proceed, Lordship?
Yes.
Lordship, before coming to the law firm involved in this case, I'll just brief the facts, very facts of the case. My lord, the petitioner,
Okay.
he now, of course, this is doing his this master degree. He was, of course, drug addict. We are not disputing that. We have pleaded guilty in the trial court also. Now, the offense involved was section 27 of the NDPS Act.
Section 27.
Yes. That is small quantity. For that,
Just wait, 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 wait. And it is-
Case number, Anita.
Section 20B2A.
Conviction at the 27 MY.
I don't think it's 27.
Yeah.
It's yes.
20, sorry.
20
euros. 20.
B, Roman 2, and A. It's involved small quantity, Your Lordship.
Yeah. Yes, my lord, it's section
20 to
20,
A. It
yes.
should be 20 Roman 2 capital A.
Yes. This is
Yes.
small quantity.
Hmm. Then what happened?
What happened, on 3/6/2022, my lord, during the police, income police, they have conducted this search operation against one, this Katem Liban. The police had the information that Katem Liban,
Hmm.
he is involved in this drug peddling.
Hmm.
So therefore, on 3/6/2022, income police has while raiding Katem Liban, they came to the room of the petitioner
Hmm.
and found that the petitioner was taking drugs,
Hmm.
consuming drugs.
Hmm.
Thereafter, a case was registered, FIR was filed on 3/6/2022 itself by the raiding police. And accordingly, income PS case number 17 of 2022 under section 21B of NDPS Act was registered against the petitioner.
But 21B is again intermediate quantity.
Thereafter, after 28 days
Hmm.
of under custody, the petitioner voluntarily went for rehabilitation after he was granted interim bail by the special judge,
Hmm.
Special Judge Pasigar. The petitioner was granted interim bail on 30/6/2022 by the special judge Pasigar. Thereafter, after he was granted interim bail,
Hmm.
immediately the petitioner, he got himself admitted at this rehabilitation center.
Hmm.
Throwing the rehabilitation center is named as Salom Rupa Foundation Drug, Alcohol, De-Addiction and Rehabilitation Center.
Hmm.
That is at
18.
in Drawing,
18.
Dibang Valley District. And the admission receipt of the same institution, it is also given as annexure 2 series. My lord may find it at page number
17.
17, yes.
Yes. Then
This is, then thereafter, Your Honor, on 20th/7/2022, the interim order was made absolute by the special judge, that is at page number 20.
page 20, annexure 3.
Yes, page number 20, the interim order granted earlier was made absolute by the special judge. Annexure 3, page 20. Then after completion of this rehab period, the petitioner was discharged from the de-addiction center on after 4 months, that is at page number 22 and lecture 4. This is the discharge slip. After completion of 4 months de-addiction, he was discharged by the de-addiction center on 3/11/2022. Now, hereafter, after he was discharged, the petitioner, he got himself admitted for this post-graduation in MA Political Science at Himalayan University.
Not discharge, bail. You got bail, not discharge. Or you mean discharge
No,
from
I
that
have,
institute?
I was,
From that hospital?
yes, yes.
Rehab center.
Because yes,
Okay.
because I have completed this rehab period. So after successful completion, I was found to be fit. So therefore, the petitioner was allowed to go out from this rehab center. After completion of the course, there is a course, my lord, course for 4 months that has to be completed. So after successful completion, I was released from the rehab center.
Then you got admitted for MA.
This all facts is not in dispute, my lord. Now after, since,
Charge sheeted.
yes, even that is the case now. While I was discharged by the rehab center, the police in the meantime has charge sheeted, they have filed charge sheet. And that charge sheet is charge sheet number 2 of 2023. And that was filed on 26/4/2023.
2023. Yes.
Now, my lord, after the charge sheet was filed, as the petitioner was charged for a small quantity, that is section 20B, Roman 2A, with a capital A. This is consumption of this small quantity. Now, for that, my lord, now, as the charges were filed against the petitioner for consuming this small quantity of this narcotic drugs. So therefore, under section 64A of the NDPS Act.
Immunity.
Yes, immunity. Immunity has to be granted to such person for consuming this small quantity. We have made an application, and that IA application was numbered as IA application number 33 of 2023 before the special judge Pasika, seeking grant of immunity from the prosecution. But that was rejected on the same day. But instead of granting immunity, the special judge on the same day had charged this charge against the petitioner, and on the same day he was convicted, and he was asked to he was fined 5,000 rupees. So we are here basically against this conviction order, because we have prayed for immunity, and my lord may kindly come to.
Show me the impugn order.
Impugn order is at page number 62.
60?
62, 62. That means the contact is to apply.
Please read.
Yes, my lord. Accused Kiri so and so is present. Learned SP so and so is present. It is argued by the learned counsel for the accused that the accused was released on bail with the condition to go for de-addiction center to reform himself. Accordingly, he has now reformed after full course of de-addiction. It is also submitted that the provision of section 64A is completely independent from section 64 of the Act. Therefore, this court may grant immunity to the accused from prosecution as the allegation is of consumption. The accused admittedly consumed drugs, but being the accused had reformed himself after completion of the de-addiction course, the immunity may be granted to the accused. He has relied upon the following judgment. We have even placed some judgment before the special judge. We will be placing these judgments now again. On the other hand, Lardner SPP has submitted that the basic point to be considered in this case is that whether the immunity is to be granted directly by this court on application of the accused or the application for immunity is to be moved by the state prosecution. Another aspect of the legal issue is that whether the section 64 is to be read along with section 64A or both the provisions are independent to each other. In this regard, London SPP has submitted that the immunity is to be granted by the state and not directly by the court. Therefore, the application may be rejected and frame a charge against the accused. However, considering the reformation of the accused and his education qualification, after the alleged offense, he has no objection to impose only of fine under principles of reformative theory of punishment. Having heard the parties, I have also produced the realized judgment of London Council for the accused. As regard the judgment of High Court of so and so, Court of Justice Bombay, in case of Fardin Firoz Khan versus Union of India versus another, it is observed that the whereas 29 of the judgment is very clear and runs as it is extremely doubtful whether the immunity can be granted where necessary measures are lacking. On careful reading of the judgment, there is no such line that the special court has power to grant immunity of for the offense of a small quantity and consumption. Straightway, hence, it cannot be acted upon without proper application of the citation. Further, as regards to the judgment of Supreme Court of India in case of so and so, it is observed that observation made in the said judgment is purely on provision of section 64A and its scope and ambit, and it has no relation with the provision of 64A, hence it is far to apply. As regards to the judgment of the so and so, the court in case of so and so, it is observed that the proceeding was passed by applying the provision under 482 CRC by the High Court and not directly under section 64A. It is also observed that there is no line to say that the special court has power to grant immunity in the light of section 64A directly. Accordingly, it is not covered by the case of the applicant. In view of the above fact, I am not in position to grant immunity to the accused. His application of reformation under section 64A of NDPS Act on the ground of silence in the provision as to who is to grant immunity to the accused. If the provision of section 64 of the Act is read together with section 64A, it is understood that the power is vested with the state or the central government to grant immunity to the accused on being satisfied of his reformation and completion of the addiction. However, if it is read separately and independently, the issue of authority is silent, which is also observed in the realized judgment of the learned counsel. Further, even if the immunity is granted to the accused, it is not absolute, but it can be withdrawn. As such, it is also point to be noted that who shall withdraw the immunity in the case of non-compliance of the de-addiction treatment. Accordingly, the application is rejected and is still disposal. In the meantime, accusation has been explained to the accused person in the language he speaks and understands, Hindi, and to which admitted to have been consuming drugs since long time back and also he pleaded guilty of the offense, but at present he claimed to be reformed himself after completing his de-addiction course. Accordingly, the accused has spent around 1 month and 26 days inside the custody. Third, board aside on sentence hearing. In this regard, the SPP has submitted that considering the reformation of the accused and his education qualification after the alleged offense, he has no objection to impose only of a fine under principles of reformative theory of punishment. After hearing the parties and considering the truthfulness of the accused and also as he has been completed his de-addiction course and plead guilty of the offense, I am inclined to sentence him a period of 1 month and 26 days and a fine of 50,000 to be deposited within 1 month. Since the accused has already spent 1 month and 26 days inside the custody during the investigation, and the punishment for the offense in this case is of maximum 1 year or fine, the period spent in the custody shall be set off against the total given sentence to the accused and award him a fine of 5,000 to be deposited within 1 month and set him at liberty. In default of payment, he shall spend another period of 3 months under the custody. Accordingly, case is then was of file be consigned into the record. Place this record before the files. Now, it is not that, Your Honor, we have filed application before the special judge, and we have even placed some judgment which squarely covers the case of the petitioner. Now, Your Honor, let us kindly, because only the issue was that even the trial court, the special court, he was not sure of his power, which has been given to the special court in terms of section 64A of the NDPS Act. Your Honor, may kindly see the difference between section 64 and 64A. Section 64 of the same act, it empowers the state and the central government to pardon a accused, pardon a person. Now, this is for the state and the central government. Now, who has been authorized to give pardon immunity to a person. Let us read section 64 first.
No, 64 and 64 here are different.
Yes.
That much.
Yes. 64, I am
Because-
saying that, Your Honor, 64A, the special court have the jurisdiction under section 64A. It is not the government, state government, nor the central government who has been authorized under this particular provision. Section 64A special, although it has not been specifically spelled out who is authorized to this grant immunity.
No,
But then
isn't
since
it-
Your Honor, 64,
But-
section 64 says that it is the state government and the central government who have the jurisdiction to this grant immunity. This is for, this section empowers the state and central government. Now,
But isn't 64A a continuation of 64?
no. Because
You have to satisfy the court. Anyway, yes, then continue. 64 is clear. It's only the state government or the central government. Okay.
yes, yes,
So you are saying that 64A can be exercised by the court, by the special court.
yes. That is my
So show me.
yes,
Yes.
yes, Your Honor. I'll show you. My understanding with regard to this, what this section is there, section 64 specifically this is spells out that the immunity can be granted by the state government and the or the central government. If only the immunity power is given to the state government and the central government, the legislature would not have brought in this section 64A because the state government has already been given the power to grant immunity to a person via this section 64. That there is no point in incorporating this section 64A. This is specific, although it has not been clearly spelled out. This section 64A, it is empowering section, that the special court has the power to grant immunity to a person consuming this small quantity. If at all the court was, if that was not the intention, there was no point in incorporating this section 64A. That is my understanding. Of course, we have some judgment supporting our case.
Miss, give me some more. please.
Now, in section 64(1) and section 306 of CRPC parametric sections, which empowers government to grant immunity. Now, Your Honor, I will just take your attention straight away to this para 26 of this judgment. Para 26. Page number 11.
Okay.
Section 64(1) of the central government or the state government may extend immunity from prosecution for any of this under the act or under the federal or under any central or state act with a view to obtaining the influence of any person. A terrorist who has been directly or indirectly concerned or privy to the aggravation of any of the provisions of the limitation of the exercise of the power are two. First, the what is state government is the case may must form an opinion that it is necessary or expedient to grant immunities to such a person. The reason for such opinion are referred to according in fact. The second limitation on exercise of the power under section 64(1) that it can be granted only conditionally. The condition being that the person granted the immunity must make a full and true disclosure of all circumstances relating to the compliance. The immunity is limited only to the offense in respect of which a tender of evidence is made. Section 64. If the condition subject to which the immunity is granted is not fulfilled by the person to whom the immunity has been granted, after recording a finding to that effect by the central government or the state government, the immunity shall be taken to have been withdrawn, and such person may be tried for the offense with respect of which the tender of immunity was made, or for any other offense of which he appears to have been guilty in connection with the same matter. Section 64. Power to tender immunity from the central government or the state government may think it is of opinion that with a view to obtaining the interest of any person declaring for being directly or indirectly concerned or due to the confirmation of any of the provision of this act or for any rule or order made thereunder, it is necessary or expedient to do so. Tender to such person immunity from prosecution or any of this under this act or under the Indian Penal Code or under any other central act or state act, as the case may be for the family is imposed. On permission being made a full and true disclosure of the whole circumstances related to such aggravation, a tender of immunity made to and accepted by the person shall, to the extent to which the immunity extends, render him immune from prosecution for any offense in the of which the tender was made. 3. If it applies to the central government or as a case may be the state government, that any person to whom immunity has been granted under this section has not complied with the conditions on which the tender was made or is concealing anything or is giving post evidence. The central government or as a case may be, the state government may record a finding to that effect, and thereafter the immunity shall be given to have been withdrawn, and such person may be tried for offense with respect of which the tender immunity was made, or for any other offense of which he appears to have been guilty in connection with the same matter. The underlying rationale of section 64 is that the government, which is vitally interested in getting hold of the country, must be allowed to assess the extent of the illness availability order to approve was under section 307 of CRPC. The object of section 64 being the same as section 307 is to logically follow it. It may be exercised at any time without cause of practice. It's known that the was immunity from prosecution has been used, but the defendants does not mean anything more than the power to withdraw from prosecution. As has been noted earlier, it will be exercised at any time before judgment is delivered. Now, because of the court under section 307, CRPC and the power of the central government under section 208, there must be had a to be report on the ground that the act in a section 8. Otherwise, the CRPC is carried act and also because the legal agreement must be over the earlier one. For the other instructor for the school had different effect. They got the English for now, particular, in my case, I have submitted, I have undergone this rate and release from we have after 4 months. And none of the most relevant one I have guessed. This is very relevant to me. There are 6, 7, 8.
Yes.
Central government of the state government to grant to any person direct or indirectly violation of any of the federal provision of any PS Act. To get use of obtaining which in case of prosecuting the economic case. Section 64 of the Act is similar to Section 306 of CRPC, whereby the court can get the court of power. It is the state of the central government that is complicated to grant immunity under Section 64. Section 64A of the Act was substituted by Act 9 of 31. In effect, for the purpose of granting immunity to ethics, Section 64A of the Act is expected for the state government. Section 64A. Immunity from prosecution to ethics, volunteering for treatment, any ethics who is charged with any offense, for example, under Section 27 or offense involving small quantity of narcotic drugs or psychotropic substances, who volunteers to undergo medical treatment for any addiction from a hospital or any institution, maintained or recommended by the government or any local authority and otherwise such treatment shall not be liable to prosecution under Section 27 or under any other section for offense involving small quantity of narcotic drugs or psychotropic substances, provided that the state immunity from prosecution may be incurred if the ethics standard undergo the complete treatment for years. Section 64A of the Act was introduced, but there is no mention about the authority by whom such immunity can be granted from prosecution to ethics. The legislature and is to produce the provision under Section 64A of the Act to grant immunity to persons who are addicted to drugs and not in any way either vending or sale of drugs. In the instance of any specification regarding the authority or the procedure to grant immunity from prosecution to the voluntary treatment is found under the inherent power. Was the proceeding by granting immunity from prosecution pursuant to the facts and circumstances in a given case. In similar circumstances, the High Court of Madras, in the case of so and so, and also in the case of so and so, invoke the provision under section 482 of CRPC for grant of immunity from the motion. Since the Supreme Court Commissioner released that this Commissioner has attended psychological counseling and also other therapy sessions over the period of the hospital and when it is stated that the substance of the income so is also going to create a negative result. This court is supposed to was the prosecutor is the Commissioner by granting immunity. In the result, the prosecutor against the Commissioner is also the file of additional discussion that Bogier are there was criminal proceeding and all. So we have also I don't know, 482 of the application is our application.
Bharat?
The unit office structured consider regard condition to draft for the to subsection 1 of the device the whole idea for what is well. And the person who has prevalence of any narcotic drugs or psychotropic substance. The consumer is to have person program and then we can edit to police media the consumer has paid to the report for the learning of and so argument that since the particular quality of drugs, he cannot plan immunity can be same or other restrictions for they only by an edit to explain small particular argument of this cannot be accepted because it is okay, that's very clear. You can plan not only by every but to have learning small quality, but also by anything which are within of this partial understanding. But the only rather is the edit should be voluntarily stick to undergo medical treatment for re-admission from the hospital or any institution maintained or by the government or local authority and undergo the treatment. The provision further next clear immunity may be reserved with the driver undergo treatment for re-admission. Therefore, immunity can be claimed even by any prosecuted under knowledge quantity specific and therefore the immunity can be granted to any prosecuted for the office under provided the other requirements are complete. The picture is stated very clearly that he underwent re-admission treatment in the recognized hospitals and he was also concealed by psychologists and psychologists in this regard. His police document. The respondent does not fully document he was admitted to Maria Hospital when he placed down on the rock of France, but only thereafter the prisoners they must get to know that he was a drug addict. He was admitted to Victoria Hospital. The biomedical report, the research was also provided. Another report, the research so that he tested negative for all the drug addicts. The report, he had a psychology also. The prisoner underwent facility session in November and December 2019, February, and March 2020. The psychotherapist by Nancy Sir noted the progressive. He has also given us a here is another subject, Christmas as well as like this popular who has very demonstrated perspective around that. He does not clean up and continue to be free of drugs. The circuit is so because the police officer and his popular officer all the documents can be given to the personal undergoing treatment for re-admission for drugs for and that is now of 50 weeks of drug addiction. Therefore, the petitioner has placed necessary support of the government. And then he has given completely re-addiction. So he prosecuted in the issue. Section 64A clearly stated any request under the business sector of the liability prosecution under section 67A of for any other offense involving small quantities. Now, the right very important. The word or is important. Not that only the consumer of small quantity can trade in. That means if the ethic has taken treatment for re-addiction, he cannot be prosecuted at all. Any further proceeding, anything in relation to offense under section 27 amounts to abuse of process of court. This so and so has required the judgment of the Bharat High Court. So and so, whereupon observation is under interest to be particular. Even the tenant actions of the prosecution in instant case may at least be able to make out an offense under section 27 of the SPS Act. The question that arises from consideration whether the accused should be referred to undergo trial was in conviction for office under section 27 of the NPS Act and would be only thereafter created to see the record benefit of section 64A of the NPS Act. Simply put, section 64A of NPS required to get to write a user of drugs from the field thereof and was in re-admission. The end of this field facilitated a life free of drugs. The court is of the view that when the actual data of the prosecution itself informs the petitioner to be a user of drugs and not to us according to the provision of re-admission. Even the fact that the article do not be said in the office under section of the NPS Act. Though this is a domain was more and more this court may ascertain to add that a decision in this case is to be arrived at on the particular facts thereof. Therefore, from the above discussion, a conclusion can be drawn that if the petitioner cannot be prosecuted for the offense under section 21 and 27A of the NPS Act, there are no methods against him to prosecute for those offenses for the office under section 27 and that is to pay immunity in accordance with section 64 of the NPS Act. With this discussion, the petition is allowed. The proceeding as the petitioner in special case number 72 and special case first. Now, all these judgments, my lord, it does not restrict or impose restriction upon the grant of special court to grant immunity. That fact was placed before the special judge, saying that since the petitioner has admitted the guilt of having consumed small quantity of drugs, this is substance. So, when it was established before this special judge, he ought not to have proceed with the trial. It was when we have made the application for immunity, seeking immunity, we ought to have consider our application. Because those very clear on it. If the substance is used, not the large quantity, but the small quantity,
this is 20B to
that is possibly this small quantity. So when it is established that the person is charged for using small quantity of this substance, then and here the trial court, special court should have stopped initiating proceeding against the person, not only the present person. In other cases, from this judge submitted by the police, it means that the substance by anyone below is a large quantity. Then there this section 64 is very clear. If it is established in any state, before the special court, the substance used was is a small quantity. Then the trial court is expressing for have the discretion to proceed with the trial proceeding. But here in this case, despite knowing the provision provided under section 64A of the NDPS Act, which says that if the drugs, whatever the substance volume is below large amount, then he cannot, that person cannot be prosecuted. But they must go before the knowledge of the trial court. But despite that, since he was not very much sure about his authority, his power to grant immunity. So he was the charge was brought against him. On the same day, trial was conducted. So the petitioner was
Convicted.
So we are basically against this conviction because this conviction could not have been, even the trial could not have been proceeded against the present petitioner in terms of section 64A of the case.
See, all these judgments which you have produced, the court has exercised power under 482. Okay, so High Court no doubt has inherent power and it's unlimited. But special court, whether the special court can exercise 64A, because here there's nothing.
Yes,
Specifically, there's nothing. Yeah.
therefore, my lord, we'll have,
Whether it's
we'll
the
have
state government which will withdraw, like how the prosecution withdraws from prosecution, something like that.
my lord.
Leonard PP, can you throw some light?
Before coming to that, your lordship, first let us understand, your lordship, what is there impugned in this order. The first part is, your lordship, that was initially when they pray for 64A, that is for immunity. And the second part is, your lordship, he is plead guilty. When he is plead guilty, your lordship, that means it has not proceeded to the trial. He has been convicted. Your lordship will find in page number 67, your lordship. We cannot ignore that aspect because now it has been concluded, your lordship. It reaches finality. Page 67, your lordship. May I read, your lordship? Admitted to have been consuming drugs since long time back, and also he pleaded guilty of the offense, but at present he claimed to be reformed himself after completing his de-addiction course. Accordingly, the accused has spent around 1 month and 26 days inside the court, heard both the side on sentence hearing, your lordship. That comes after, your lordship, order of conviction. In regard, learned special PP has submitted that considering the reformation of the accused and has his educational qualification after the alleged offense, he has no objection to impose only of the fine under principle of reformative theory of the punishment. After hearing the parties and considering the truthfulness of the accused, and also he has been completed his de-addiction course, plead guilty of the offense, I am inclined to sentence him to a period of 26 days and fine of so and so to be deposed within 1 month. Now, your lordship, this has to be challenged first. It attained its finality, my lord. And so far as your lordship, this revision is concerned, your lordship is well aware, if a person is plead guilty, the 374 cannot be, your lordship, attracted. However, your lordship, there is a slight window is there, your lordship, where it says, when the plead guilty is not voluntary and free one, then they can invoke 374. They can still prefer the appeal. But now here is a case, your lordship, they file a revision for their prayer which has been rejected by the learned court below, made under section 64A. But after that, your lordship, the proceeding has been concluded. Now, if that proceeding has not been opened again by way of appeal, this honorable court may not, in my humble understanding, Your Lordship, this honorable court may not have the power to directly interfere or invoke 482 for, Your Lordship, recalling the order for section 64A. First, they have to overcome, Your Lordship, the order of sentence, Your Lordship. His plead guilty, Your Lordship. It's very clear in the order itself, Your Lordship. And so far as, Your Lordship, 64A is concerned, Your Lordship, section 64 of the NDPS Act, it speaks about the power of the state government and the central government. And it has been held by the Honorable Supreme Court that if it's required any aid, then 306 and 307 has to be read along with the section 64. But, Your Lordship, section 64 doesn't provide any power for the state government or the central government. It simply says that two conditions, Your Lordship. One is, Your Lordship, he should be an addicted person. And he should be, Your Lordship, booked under the provision of this code. And secondly, Your Lordship, that immunity is not absolute, Your Lordship. Meaning thereby,
It can be withdrawn.
yes, meaning thereby during the pendency, Your Lordship, pendency of this trial or the proceeding, if the concerned person come before the court, first he has to be an addict person. Secondly, the quantity should be, because this is a reformative provision. Because the other provisions are stringent, no doubt, Your Lordship. But so far as the 64A is concerned, it confined to the consumer actually, who are actually victim. So if they come with a de-addiction, Your Lordship, this certificate and all, first he has to satisfy the court, he is an addict person. For that, he must possess a certificate. And he has done his course from the government institute. It clearly says the recognized government or local authority and undergo treatment. And, Your Lordship, second part comes the quantity. And later, Your Lordship, proviso comes, the prosecution may be withdrawn if addict does not undergo the complete treatment. That can be, Your Lordship, done by the special court only, Your Lordship. Because here, the 64A doesn't speak about state government or central government, Your Lordship. And neither it speak about, Your Lordship, court. It doesn't, if
Nothing is said.
nothing is there, Your Lordship. It doesn't, neither, otherwise, Your Lordship, if every time 482 is invoked, then 64A will become redundant, Your Lordship.
Why you have pleaded for 64A at the same time pleaded guilty?
Yes, Your Lordship. Actually, Your Lordship,
my lord.
in my,
My lord. What 64A says? One, two, avail the immunity is granted under section 64A. One, the condition is that one has to go, go for this de-addiction
center.
center.
No,
If
you
I'm
mean
not
immediately?
addicted, my lord,
Yes.
I will not be, I'll be debarred from this, receiving the privilege granted under this
No, no.
section 64A.
Okay, agreed.
One has to be
You
addicted,
went for the treatment, you
Yes.
completed the
Yes.
treatment also. So in that case, if you were invoking 64A, why you pleaded guilty again? Because the prosecution should not have been carried out at all.
Yes.
If 64A is to be given, if 64A relief is to be given, even charge sheet should not have been filed actually.
My lord, this section 64A itself has been inserted for the addicted person, those who
Yes,
is
yes,
consuming this
That we agree.
substance.
Mm.
If, my lord, I have not
But
admitted
yes, yes,
pleaded guilty, I would not have been this allowed to avail this, the privilege of this section 64A. It clearly says in this rider, provided that the said immunity from prosecution may be withdrawn if the addict does not undergo the complete treatment for the addiction. Because therefore, to avail the immunity provided under section 64A, one has to be an addicted. And one has to go, ready to go for this complete treatment for the addiction. Yet we have done. Even the bail, interim bail was granted in view of my readiness to undergo for this, going for this de-addiction treatment, and which I did successfully. my lord, to my humble understanding, this section 64A, it has been incorporated in this section. Later on, in view, in order to give some privilege to an edit. Otherwise, this is section 64 and section 64A. This is from this conjoint reading. It is very clear. In section 64, court was not given the power to this grant immunity. Section 64. It specifically mentions the state government and the central government. Because the court power was missing in this section 64. Therefore, the legislative intent to incorporate this section 64A was that court, special court, who is trying such an offense, it has to be given power. That is why, this is my understanding, that is why this 64A has been inserted. Otherwise,
Now, your lordship, the second part, your lordship has rightly pointed out, on the very day of the application for 64A, he has been convicted and his plead guilty was accepted, your lordship. So now, your lordship, the question here is, your lordship, directly whether interfering the sentence order, your lordship, whether this court can embark into the, your lordship, the rejection of the 64A or not, your lordship. And so far as your lordship, section 401 of the CRPC, now the cognate section would be in BNSS, your lordship, it empowered the court to convert it into appeal also, your lordship. Because, your lordship, the section 375, your lordship, there is a bar. However, your lordship, it has been held, which is reported in criminal law generally in 1980, your lordship. It says, when that plead was not voluntarily and free, then the embargo under 375 will not operate. It will still, court can exercise 374.
It's already for.
Yes, your lordship, it's for appeal, your lordship. I mean the old code, because this case is pending, your lordship, prior to the coming force of the BNSS, your lordship. So now, your lordship, 374 is the appeal from conviction. And now the second part is 375, no appeal in certain cases when accused plead guilty. Yes. Now, your lordship, to clarify that, because your lordship, I am, your lordship, quite more concerned about, your lordship, the succeeding part. 64A rejected, then he was convicted, your lordship. Now, when it is convicted and sentenced, it reaches finality, your lordship. Now, the question here is, they have not challenged that plead guilty. They directly come and challenging that particular part where the learned special court has given an observation that he don't have the jurisdiction to take up the matter, exercise the power in 64A, because the provision is silent.
The prayer portion.
Yes. Prayer, your lordship.
Sit and wash aside the order dated such and such. Grant immunity to.
Yes, this is the immunity, your lordship. (23)(2) is the general one, your lordship, and 2 is the specific for your lordship, immunity, your lordship.
Set aside and wash order dated 23/2, so they are basically covering everything with that. Okay. So, and then what does, so you're saying that since accused has pleaded guilty, no appeal will lie?
Yes, your lordship. No, your lordship, the rather exception is there, your lordship. If your lordship, that they ought to have taken that plea, actually this is coming from the prosecution side, I am being very fair, your lordship. If there is, your lordship, if that plea is not voluntary one and free one, then 375 will not come in the way. It will still 374 will be maintainable. Your lordship, this is the judgment of the reported Kerala High Court in 1980 CR, the criminal law general, your lordship. Paragraph, your lordship, I've written there, paragraph from 2 onward, your lordship. And this is my copy, actually. Sorry, I'm sorry, your lordship. 228, Your Lordship. May I read, Your Lordship? Before, this is the 1980 CRLJ NOC 39 Kerala, Your Lordship.
Yes, there are two.
Yes, Your Lordship. There are 2 to Your Lordship 8. Before I go into the merit of the case, it may be necessary to observe that 3 is confusion in the mind of the parties as to whether the learned session judge exercise appellant or revision power is setting aside the conviction and sentence. The state has evidently treated the case as one where the session judge has invoked his revisional power in making the impugned decision. There was a contention for the state before the learned judge that the appeal should not be entertained because of the bar under section 375 of the Code of Criminal Procedure. Evidently, to meet this, counsel for the accused submitted in that court that at any rate, the facts were such as to justify invoking the revisional power of the court, and therefore, even if not entertainable as an appeal, the grievance of the appellant could be heard as if he was invoking the revisional power. The court found that this could be done, but that by itself need not be taken as a court order converting the appeal into a revision. I do not find any order in judgment of the learned judge treating the case as one falling under the section 397 of the code. He was only remarking in answer to contention of the state before him that, as pointed out the appellant, it would be possible to entertain the challenge to the judgment of the trial magistrate even as a revisional court. The appeal was not renumbered as the revision was not revision nor was it directed to be renumbered. In these circumstances, I must take it as the learned judge disposed of the appeal without converting into a revision. Now 375, Your Lordship. The answer to the controversy as to whether the appeal was maintainable would in a way also answer the contention of the party on merit. The case of the accused respondent in this revision is that there was no genuine plea of guilty, and therefore section 375 would not apply. In that event, the appeal would be maintainable. If that be for the very same reason that there was no plea of guilty, the order has to be set aside as found by the learned session judge. Hence, if once the appeal is held to be maintainable, despite section 375 of the code, it would automatically follow the appellant before the session judge was entitled to relief, which was granted to him by the learned judge. Section 375 of the code provides that, notwithstanding anything contained in 374, where an accused person has pleaded guilty and has been convicted to such plea, there shall be no appeal if the conviction is by the magistrate or first-class magistrate, except as to the extent or legality of the sentence. The challenge before the learned judge was not to the legality or extent to the sentence, but to the conviction. Section 375 corresponds to section 412 of the old code, and insofar as it is material for the purpose here, there is no difference between two sections. Therefore, the decision which have interpreted section 412 of the old code may be relevant in considering the case before me. Section 251 of the code provides that when in a summon case, the accused appear or is brought before the magistrate, the particulars of the offense of which he is accused shall be stated to him, and he shall be asked whether he plead guilty or has any defense to make, but it shall not be necessary to frame a formal charge. It agreed by both sides that it is section 251 that is applicable to the fact of the case here. Section 252 provides that if the accused plead guilty, the magistrate shall record the plea as nearly as possible in the word used by the accused and may, in his discretion, convict him thereon. Evidently, the conviction of the accused on a plea of guilty is not automatic and does not follow merely because such plea is made. Despite the plea that the court has a judicially consider whether the conviction would be warranted, and that is where there is a scope of exercise of discretion of the magistrate. Various factors may have bearing on whether, despite the plea by the accused that he is guilty, he has to be convicted, or whether the case has to be tried and disposed of on the evidence that may be taken at the trial. The duty cast upon a court to decide whether the plea by the accused that he is guilty should be sole basis of conviction is solemnly duty, the exercise of which call due for due care and caution. If the magistrate has reason to feel that the plea entered by the accused is not voluntarily, he has to prove further into the matter, and he is to act upon such plea only if he is fully convinced and the accused plea guilty of his own free will. Equally relevant in the case where court has reason to feel that the accused may not have understood the charge fully, the fact as well as the inference drawn from the fact stated in the charge. It is possible that the accused may not be properly advised because of the situation in which he is placed. maybe he entered plea of guilty, assuming that the consequences may not be serious. In short, except in a case where the court feel that the plea of guilty made by accused was under circumstances where he was well advised as to what he was pleading and was well aware of the consequences of his plea, the court may not justify in acting upon the plea and convicting the accused without any evidence. It is only when there is a genuine plea of guilty made freely and voluntarily that the bar under section 375 of the code would apply. There may be instances where the fact averred or pleaded by the prosecution do not amount to an offense. Pleading by the accused that he is guilty does not preclude him from filing an appeal against the conviction. That is because his plea may amount only to the admission of the fact averred by the prosecution, which even if true, may not be sufficient to constitute an offense. Reference may be made in context of the decision of the High Court of Madras in re U.R. Ramesh Swamy AIR so and so. In that case, the accused represented himself to be a merchant dealing in broken glass piece and obtaining the advantage of rupees 300 from the complainant in two installments, agreeing to supply certain quality of glass piece to him within a fixed period. The glass piece were not supplied within the stipulated period, and when he was pressed by the complainant, the accused gave a check to the complainant, which was dishonored, as there was no balance to the credit to the accused at that time. On this fact, a charge under 409 of the IPC was framed, and the accused pleaded guilty to that charge. The magistrate found that there was no intention on the part of the accused to cheat or defraud at the outset, and that was apparently due to circumstances beyond his control. The accused could not act according to the term of the contract. The magistrate also found that the accused of issue of check was not an act of fraud, but really was proof of good faith. But nevertheless, the magistrate was of the view that offense under section 409 was made out because the accused did not use the money for the purpose of which it was intended, namely to be used by him in the capacity as merchant, and as accepting the plea of guilt, the magistrate convict the accused. The appellant court held that the plea of guilty did not bar the appeal from being entertained. That was because if the question be one of the admission of all the fact and the fact pleaded are not disputed, even then the accused would not be guilty. When a person advance money for purchase, it not an entrustment of the specific purpose. The money so advanced becomes the money of the person to whom it was so advanced, and he is free to utilize it otherwise than for the business. This view is contrary taken by the learned magistrate, was found to be unsustainable. Plea of guilty did not preclude to challenge to interference drawn. In Manikam Pillai referred to the Madras decision just awarded to the accused sought to get himself reinstated in the post of Karnan by production of a certificate of having passed a certain examination. The certification accordingly to him referred to him, but the fact referred to another man of the same name. Though the accused pleaded guilty to the charge and he was convicted under 419 and 511, the appellant court found that the element for the offense under 419 had not been made out of the fact indicated, and therefore there would be no bar in entertaining the appeal. So in the case with the decision in Emperor versus Sat Narayan AIR so and so, reference is made that the same Madras decision in the case of Inri Grupa Marguda so and so, where the accused was convicted for culpable homicide not amounting to murder on his plea guilty. His admission was understood to be a physical act attributed to him, namely that he beat his deceased wife and that she died. But it was open to the question whether he admitted the existence of any connection between the beating and the death of any intention to cause bodily injury as was skill likely to cause death. The court held that the conviction on the plea of guilty could not be sustained and accused must be retried. The case of Emperor so and so was one where the plea of guilty was made under a misconception of one's right in a property, and in such a case to the bar under so and so was held not to apply. In case before Chaudhry Justice in Emperor versus so and so, the accused pleaded guilty in a statement submitted by them, while at the same time stating that the accused were acting only as agent. In an appeal against the conviction, the appellant found that if they were agent, they would not be criminally liable in law. Necessarily, therefore, the plea of guilty did not preclude an appeal. The scope of bar under section 412, that is now 375 earlier, was examined by the court and the Judicial Commission Manipur in decision reported in Howvijam versus Heisnam 1972 CRLJ so and so, that the plea must be considered with caution to key note of the said decision. In the case before me, the accused has been arrested by the excise officer. So now, Your Lordship, the principle is very clear now, Your Lordship. So now, Your Lordship, according to them, and so far as the record is concerned, he plead guilty only to get, Your Lordship, that immunity, your lordship.
Immunity.
Yes. So, your lordship, if that is the ground, then they ought to have prefer an appeal where this honorable court has a plenary power to even, your lordship, acquit your lordship, the learned, victim, accused person, your lordship. And now, your lordship, the section 401 of the CRPC, your lordship, empower this court that this court can convert this revision into appeal as well, your lordship. Because, your lordship, he has not on that day, his application for 64A was not only rejected, he was convicted, your lordship, on plead guilty. That has to be taken into account, your lordship.
This troubling news. Anyway,
Now, your lordship will find the power of this honorable court in 401 of the CRPC, your lordship. Since, your lordship, this case was pending prior to the coming into force of the new code, that old code will apply, your lordship.
this was filed when?
Your lordship, 401. Or it was filed prior to. Prior to that, your lordship.
Prior to that.
Yes, prior to that. So now CRPC will govern you. It was pending as on that. Lordship will find in 401 of CRPC, your lordship.
Conclusion, no?
Yes, 40. Because that part, even if this honorable court is inclined to invoke 64A, that whether it will be exercised in revision or appeal jurisdiction. Or 01, your lordship. Yes, now your lordship, 401, High Court power of revision. Your lordship may directly come to subsection 5, your lordship. Where under this code, an appeal lies, but an application for revision has been made to the High Court by any person, and the High Court is satisfied that such application was made under the erroneous belief that no appeal lies thereto, and that it is necessary in the interest of justice to do so, the High Court may treat the application for revision as a petition of appeal and deal the same accordingly. So now this court has a power, your lordship, to convert it into appeal also, treat it into appeal.
That one.
We have not pleaded that case in our this revision petition. But then from the initial, from the initial stage itself, from the time when the investigation was carried out, from there itself, there is a defect in this procedure. My lord,
I'll see.
yes, my lord has seen the affair. It says while they were searching for the one accused who was connected with income, some income PS case number, then only they inadvertently had entered the house of the present petitioner. And
No, no, on the facts, it's okay.
Yes.
You are a drug addict, you have
Yes.
undergone the required treatment and it's small quantity. Okay,
Yes,
that is
and
fine.
even I have all the documents in my favor
So,
because
no, just
the
the
certificate.
technicalities, I'm trying to think about it. So we'll
No.
see what best.
In
can be done.
addition to that, my lord, section 50 of this NDPS Act, it says
Section
section
50,
50, yes. It says that there has to be warrant from the concerned magistrate for this is taking up any search operation. In this case, it was not done. That is a mandatory this provision. If that is not
No,
done,
no, no,
This
this,
can be raised at trial stage, not now.
this is, yeah, out of the thing. That is only for trial. Now you're already convicted.
on that count also, there is some judgment. The conviction, this judgment.
No, I'm
order,
trying to help
was-
you.
That was twice.
I'm trying to help you. It's just that the technicalities, nah,
Yeah,
that
yeah.
there are certain technical errors. So just trying to figure it out.
Yes.
Anyway,
Basically, my case is only on this section 64A. Let us, my lord, may kindly read both section 64 and 64A. The legislative intent, although it is not clearly spell out either neither in section 64 nor in section 64A.
No, agreed,
But-
64A also agreed,
Yes.
but how to go about it? That's the thing. How to go about it, whether it's to be given by the special court or whether it is the state which will withdraw the prosecution. And here also at this stage, whether it should be a revision or an appeal. So all these things are
That,
there.
that is
So-
there,
so,
but then,
uh,
my lord, we have invoked section 482 along with this, the provision for revision.
Hmm.
What, and the citations we have placed before, my lord. Here also in all those cases, section 482 was involved, and while exercising this inherent power of this section, under section 482,
Yeah.
all the proceedings were quashed by the Honorable High Court.
Heard learned counsel, she said and said for the revision petitioner, revisionist slash petitioner. Heard learned additional PP, the FA for the state respondents. Order is reserved. The other matters, I think we'll list all after 2 weeks.
Yes, your lordship.
Much obliged.
My lord.
Which one?
Continue.
16, item number 16, interim order passed earlier, will continue till the next day. In that- 15 also.
Short matter, and moreover, the paper book has been given furnished to all the councils. So if this matter can be taken up on Friday. It's a very short
Friday.
matter, I won't take. Thursday.
Friday is my last day.
No, Thursday, your lordship, I won't be here. Your lordship. Thursday, again, it's
Thursday.
difficult.
Thursday, ma'am.
Okay, item
Item 15, ma'am.
15, item
It's
15,
criminal
Thursday.
appeal, your lordship.
Place it on Thursday.
Lordship, item 14,
My
there is
lord-
an also interim order, Lordship.
Item 14.
Lordship.
Item 14 also, interim order passed earlier, shall continue.
Well, on-
till the next day.
On 10th, your lordship, I won't be available, your lordship. I have difficulty because I have been endorsed in that case appeal, your lordship. That my brother is.
So 10th you will not.
10th,
be
I
there.
am not, I will not be available.
11th also I'm not taking up. So next week, next week.
Immediate after your lordship break, your lordship.
The other things that you said, we can take up from there.
No, learned PP is not going to be there. 11th, I don't want to take. Because
No, 10th, 10th.
I-
Oh, 15, yes, 15.
Matters are being taken up by the public prosecutor also, additional PP. There are 4 additional PPs, even I was a PP, madam.
My brother
No,
should
but-
understand the
But
difficulty.
that's
Yes,
the briefs. Oh,
Yes,
it
Your
is
Honor.
given to a certain person.
Very
who is
short
having-
matter.
Next week, next week, next week.
Next week, madam, maybe it's
Uh,
date if I can get.
Uh, So 21st,
So vacation only one.
yeah, because 11th is the last working day. And 21st is
22nd, yeah.
22.
Yes.
Lordship, in item number 13 also, interim.
Interim, item 13 also, same interim order passed earlier to continue till the next day. Now 2 weeks.